In very simple words, what does this mean? That suppose there is a national emergency issued on any of the grounds is already in operation. The president can proclaim a fresh national emergency on any of the grounds, irrespective or notwithstanding of the fact that one national emergency is already in operation. Now, this is what I am saying is a proclamation, once it is issued, it has a lifetime of 1 month, and within 1 month it needs to be approved by both the houses of the Union Legislature. But suppose on the day of issuance of the proclamation, the Lok Sabha is dissolved. The emergency provisions of Indian Constitution are contained in part 18 of the Constitution between articles 352 to 360, and the Indian Constitution talks about or stipulates 3 kinds of emergency: the national emergency, which is imposed under article 352, the constitutional emergency, also known as state emergency or president's rule, under article 356, and the financial emergency under article 360. Now, whenever an emergent situation occurs, the Constitution transforms itself from a federal form of government to a unitary system. And that is a special feature or a distinctive feature of the Indian Constitution, which also creates some sort of doubts and aspersions in the minds of Western thinkers that what kind of federations the Indians have established for themselves. But I am not touching upon that query once again, because we have already dealt with it in our previous classes, and we have noticed and we have now noted for all practical purposes that India is a federation, but it is a federation with unitary bias. So let us have a look at the emergency provisions. The emergency provisions are contained in part 18 of the Indian Constitution between articles 352 to 360. The Indian Constitution stipulates 3 kinds of emergency, and they are national emergency, constitutional emergency, and financial emergency. National emergency is imposed under article 352, constitutional emergency is imposed under article 356, and financial emergency is imposed under article 360. Now, the word that is used in the Constitution as far as national emergency is concerned is just emergency. It says that under article 352 the president can proclaim emergency when he is satisfied that the security of India or a part of it is threatened by war, external aggression, or armed rebellion. So let's have a look at that. So let's have a look at national emergency. Under article 352, the president can declare a national emergency when the security of India or a part of it is threatened by war or external aggression or armed rebellion. So what is to be noted here? First is who can proclaim the national emergency. It is the President of India. In fact, all the emergencies are proclaimed by the President of India. And when he can do so when the security of India, it means the security of entire of India, which can be external security, internal security of entire of India, or a part of India, say in a particular state or a part of a state, a district or anything, a part of India is threatened by what? By 3 things: war, or external aggression, or armed rebellion, or any of them. It means that a national emergency can be proclaimed by the president at any time whenever he is satisfied that the security of India or a part of it is threatened by either war or external aggression or armed rebellion, or all of them. Do you understand this? Now, this third ground, armed rebellion, is a later day injection by the 44th Constitutional Amendment. In fact, the original Constitution of 1949, the third ground in the original Constitution of 1949, the third ground was internal disturbance, which was replaced by the word armed rebellion by the 44th Constitutional Amendment Act. And this was done because the word internal disturbance has a very wide connotation, and it can be misused for political purposes, and which we have already seen when the internal emergency was declared. In fact, when the emergency is declared on the grounds of war or external aggression, it is known as external emergency, whereas when it is done on the grounds of armed rebellion, it is known as internal emergency. But at this point, it is very important for you to note that the words external emergency, internal emergency, or even the word national emergency is nowhere mentioned in the Constitution. The Constitution just says the President can proclaim an emergency. So there is simple proclamation of emergency. These are terms which are either judicial innovations, they are either judicial interpretations, or they are just used in the terms or in the context of governments. So let's have a look at this. The President can also issue the different proclamations on grounds of war, external aggression, armed rebellion, or imminent danger thereof, whether or not there is a proclamation already issued by him and such proclamation is in operation. This provision was added by the 38th Constitutional Amendment Act of 1975. In very simple words, what does this mean? That suppose there is a national emergency issued on any of the grounds is already in operation. The President can proclaim a fresh national emergency on any of the grounds, irrespective or notwithstanding of the fact that one national emergency is already in operation. That is what is the meaning of this sentence. When a national emergency is declared on the ground of war or external aggression, it is known as external emergency. On the other hand, when it is declared on the ground of armed rebellion, it is known as internal emergency. But remember, external emergency, internal emergency, national emergency, these words are not mentioned in the Constitution. A proclamation of national emergency may be applicable to the entire of country or only a part of it. Now, this is a natural corollary. If you look at the text of Article 352, which says that when the security of India or a part of it. So hence, if only a part of India's security or a part of India where the security situation is volatile is concerned, it would be ambiguous for the President to impose national emergency over the entire territory of India. Rather, he can bring the situation under control by imposing national emergency to the concerned area. Do you understand this? And therefore, a proclamation of national emergency may be applicable to the entire country or only a part thereof. That is what you need to keep in mind. Originally, the Constitution mentioned internal disturbance as the third ground for the proclamation of national emergency, but the expression was too vague and had a wider connotation and could be misused for political purposes. And hence, the 44th Constitutional Amendment Act 1978 substituted the words armed rebellion for internal disturbances. Though the 44th Constitutional Amendment Act made some hasty changes, like say for example, it removed right to property from the Part 3 of Indian Constitution, but this is something which the 44th Constitutional Amendment Act did right when it made the word more specific in nature, because internal disturbance can be interpreted in myriad of ways, whereas armed rebellion is very specific. It means there is a rebellion in which violence using arms is being done. Anyhow, the President, however, can proclaim a national emergency only after receiving a written recommendation from the Cabinet. Now, this is a very important line as far as the proclamation of emergency is concerned. Keep this in mind, that the President can issue an order of proclamation under Article 352 only when he has received a written advice by the Cabinet Ministers. Not the Council of Ministers, but the Cabinet Minister, which is a smaller inner group, the more powerful ministers. It means the major decision making body within the Council of Ministry. Now, this was also done because of what happened in 1975. Now, there are allegations that the then Prime Minister asked the President of India to issue an emergency without consulting her cabinet members. And therefore, this is now an explicit requirement for the proclamation of emergency under Article 352. So keep this in mind, that written advice of whom? Cabinet Ministers, and not the entire Council of Ministers. Cabinet is a subset within the Council of Ministers. This we have already seen in one of our previous classes. The 38th Amendment Act of 1975 made the declaration of national emergency immune from judicial review. But you know, judicial review is a part of the basic structure, and you cannot make anything completely immune from judicial review. However, that controversy did not rise because 44th Constitutional Amendment Act 1978 later on deleted that provision, but it was subsequently deleted by the 44th Constitutional Amendment Act. Let's now have a look at the duration of national emergency. It means for what length of time the proclamation of emergency under Article 352 can remain in force. So let's have a look at that as well. The proclamation of emergency must be approved by both the houses of the Parliament within 1 month from the date of issue. It means if it is issued at a particular date before the expiry of 30 days counted from that date of issuance, it must be approved by both the houses of the Parliament. And unless it is done, let us see what happens. However, if the proclamation of emergency is issued at a time when the Lok Sabha has been dissolved or the dissolution of the Lok Sabha takes place during the period of 1 month without approving the proclamation, then the proclamation survives until 30 days from the first sitting of the Lok Sabha after its reconstitution, provided that Rajya Sabha in the meantime has approved of it. Now, this is what I'm saying is a proclamation, once it is issued, it has a lifetime of 1 month. And within 1 month, it needs to be approved by both the houses of the Union Legislature. But suppose on the day of issuance of the proclamation, the Lok Sabha is dissolved, or suppose within the expiry of that 30-day period, the Lok Sabha has dissolved, then the proclamation will survive for 30 days counted from the day of reconstitution of the Lok Sabha, provided that in the meanwhile the Rajya Sabha has approved of it. Now this is a very important thing, and you can say, and thus the Rajya Sabha, unlike the Legislative Council, is not a secondary chamber, rather it is the second chamber. Anyhow, if approved by both the houses of the Parliament, it means within the expiry term, the emergency continues for 6 months and can be extended to an indefinite period with an approval of the Parliament for every 6 months. It means what is the total time or the maximum time period for the national emergency? It is indefinite. Every time it is approved, it gets a fresh life of 6 months. But again, within those 6 months, it needs to be approved again for its continuance for another 6 months. But again, within that 6 months, if the Lok Sabha gets dissolved or on the date when it is approved, then what happens? Again, the same situation. It survives for another 30 days counted from the reconstitution of the Lok Sabha, provided that Rajya Sabha in the meanwhile has approved for its further continuance. Let's have a look at that as well. However, if the dissolution of the Lok Sabha takes place during the period of 6 months without approving the further continuance of the emergency, then the proclamation survives until 30 days from the first sitting of the Lok Sabha after its reconstitution, provided the Rajya Sabha has in the meantime approved of it. That is what you need to keep in mind. Now, how can we discontinue the emergency? Now, before we go into that, let's have a look at what kind of approval is required in both the houses of the Union Legislature for the continuance of the national emergency. Every resolution approving the proclamation of emergency or its continuance must be passed by a special majority in either house of the Parliament. It means a majority of the total membership of the House and a majority of not less than 2/3 of the members present and voting. So what does this mean? That every time you want to approve a national emergency, whether in the first instance or subsequently, it needs to be approved by a special majority in both the houses. And there's one more instance where you see the equal power of Rajya Sabha vis-a-vis the Lok Sabha. A proclamation of emergency may be revoked by the President at any time by a subsequent proclamation, that he issues a proclamation, subsequent proclamation, that the emergency is withdrawn. Such a proclamation does not require parliamentary approval. It means the President can do it on his own. But the issuance need for its continuance parliamentary approval. Further, the President must revoke a proclamation if the Lok Sabha passes a resolution disapproving of its continuation. Now look here, this is a typical feature to note here with respect to national emergency. For its approval, you need both the houses of the Parliament to pass resolutions by special majority. whereas for its disapproval, Lok Sabha would be enough to pass a resolution by a simple majority. If the Lok Sabha says that it wants to discontinue with the emergency, then the President must discontinue the emergency. The 44th Constitutional Amendment Act 1978 provided that where 1/10 of the total number of members of the Lok Sabha give in writing a notice to the Speaker or to the President if the Lok Sabha is dissolved or not in session otherwise, a special sitting of the House should be held within 14 days for the purpose of considering a resolution disapproving the continuation of the proclamation. It means suppose the 1/10 of the total members of the Lok Sabha, they give in writing to the Speaker or to the President when the Lok Sabha is not in session that we want a special sitting for disapproving the continuance of the national emergency. It means we want to discontinue the national emergency. Then such a sitting, special sitting, must be organized by the Speaker or the President, as the case might be, within 14 days from the date on which the notice was received by the members. Anyhow, a resolution of disapproval is different from resolution approving the continuation of the proclamation in the following two respects. And what are they? Let's have a look at this. And this can become part of your question. Very simple. The first one is required to be passed by the Lok Sabha only, while the second one needs to be passed by both the houses of the parliament. It means disapproval. For disapproval, Lok Sabha is enough. But for approval and continuance, both the houses must pass resolution by special majority. For disapproval, only Lok Sabha by simple majority. It would be enough. Because no majority is mentioned, whenever no majority is mentioned, we deem it to be simple majority. The first one is to be adopted by a simple majority. It means the disapproval thing. While the second one needs to be adopted by a special majority. So that is what you need to keep in mind.